you say go. Right?
It's flashing red, right?
It's flashing red.
Okay, you
Yes.
guys are ready whenever you're ready.
Okay.
Or go whenever you're ready. You know, I try to see.
Hi everybody, welcome. We're Group 1. My name is Tyler. This is Mary Jane, Alexis, Ebony, and Dan. And we're talking about anti-discrimination law for your recruiting practice. Laying down the law, as it were, and getting things going here. I'm going to take you through some introductory things to make the cases and such talked about by the rest of my team a little easier to understand. So discrimination is wrong. We agreed to that and we say that we believe in it, but in reality we still have preconceived biases in the back of our minds. So we can't handle anti-discrimination on our own. So we have laws in place that help us achieve equal opportunity. So you have the right to sue if you feel that you've been discriminated against in your hiring process or what have you. You have power to seek legal recourse, okay? And we'll talk about burdens of proof and how that shifts from a plaintiff to a defendant, the company to the interviewee and back, okay? So you have the right to sue. Disparate impact is one way that discrimination can affect you. The key word is intent. It's a policy that either very obviously or perhaps more subtly discriminates against a protected class, be it race, nationality, blue eyes, different colored beard than hair, or whatever. Okay, so an example is a qualified individual who otherwise would be okay for the job is blocked from the career opportunity by whatever discriminatory policy is in place. And the key word is that in court you show the intent. Okay? And the nature of the policy reveals whether it has intent or not. In a different way, adverse impact, the key word is statistically, who does it disproportionately affect? Okay? So what you would take to court is a pie chart saying that blue-eyed, brown hair, red beard people are blocked from this particular career opportunity. But on paper, it's a neutral policy. So you're looking for that statistical impact. It's not so obvious. It doesn't say it on the job application. It doesn't say it in the policy, but because of the demographics, because of where the business is, because of whatever real evidence that you bring to court, you see the discrimination there instead, the statistics. So again, the difference is, because this is a great thing to put on your test, disparate impact has the intent to discriminate, and adverse impact does not. So there's different burdens of proof because you have to make up all of the elements of a claim when you take something to court. Okay, so we have the difference between these two here. Okay, the 13th Amendment, we remember from high school history, slavery is illegal, plain speech. But I want to touch on a notion that we may have been desensitized to over the years, and that is to reach this point, we, as a country, we had families torn in half, killing one another, giving their lives, and a lot of work went into this point. It's unthinkable to us that this noble creature, the human being, could treat another human being as property. And we still have modern human trafficking today, so we need to appreciate this, and we need to keep making strides forward. We mustn't get comfortable and complacent. The 14th Amendment, it defines what citizenship is, and that's great, whether you're born or naturalization. So it defines what citizenship is, and then more importantly for your recruiting practice, it's also going to define the constitutional grounds for equal opportunity employment, equal protection under the law, I should say. So due process of law, before this, it was easier to be defended in court if you were more wealthy or more esteemed or more prestigious or what have you. This is legislation that sets the standard of everyone gets the same protection. So some court vocabulary, I'm going to start moving over here. And where the arrow goes is where the burden of proof goes. So I bring the elements of a claim going this way, and the business defends with a bona fide business necessity or qualification going this way. I'm going a little fast, I know. Pretext is going this way, saying that the neutral policy is BS. Okay? How does this apply to me? We talked about in this class that recruiting is one of the first jobs that HR is likely to get into. So I'm going to be using this very quickly, and I have to look at candidates and resumes and interviews with an open mind. I have to be unbiased. Okay, I can take this home. I live with my parents and a younger sister, and a cat. Okay, I've had conflicts with all of them, including the cat. So you need to take an unbiased, open mind at home as well, with your friendships and your family. You know, if you have a dating relationship, marriage. Lifeguarding. I like swimming. So I got a lifeguard job years ago. I need to enforce rules equally to everybody, and everyone gets equal protection who's in my zone, right, that I'm scanning, just like everyone gets. It's kind of like the 14th Amendment, if you think about it. So I can use it when I lifeguard, I can take it to work there. Self-defense. Your first line of defense is awareness of your environment, right? So we have like, some people have some strange ideas about what's dangerous and what's not dangerous. What I'm saying is, you need to avoid bias when you're aware of your surroundings as well. You can't discriminate to protect yourself, if that makes sense. So you can take this anti-discrimination law to other parts of your life, whether it's other jobs, whether it's your life at home, or other things that you enjoy, or the disciplines that you practice. You can carry this into all parts of your life, talking with your cat. So what did I talk about? We talked about disparate versus adverse impact. Remember, intent versus face value neutral policy. Some court vocabulary, because my teammates are going to get into some cases, so you'll need to know what they're talking about. Foundation in the Constitution, 13th and 14th Amendment, and applying it to my life. Okay, now I'm going to introduce Mary Jane, who's going to talk about EEOC and Title VII and some cases.
So before I get started, I'm going to pass this around. This kind of has to do with my job. It's big considerations of interviewing, so you guys can look at that. So what I'm talking about is the EEOC, which is a federal agency that enforces Title VII rights against workplace discrimination. Title VII has different protected classes, and this ranges from race, color, national origin, gender, and religion. So the first case I'm going to talk about is Phillips versus Martin Marietta Corporation. This case involves sex discrimination. A woman had applied to this company, and she was denied the position because she had a child who was still in school. She was considered an unreliable candidate because of this. So she sued because she felt she was being discriminated against because she was a woman. The Supreme Court ruled that the Martin Marietta Corporation was in fact discriminating against women because they had men who also had school-age children, and they had no problems hiring them. So again, they showed sexual discrimination because they held them to different standards. So for Griggs versus Duke Power Company, this involves adverse impact. So the Duke Power Company set up in a lower class minority area, and for one of their qualifications, they said you had to have a high school diploma. So there was a lawsuit, and Griggs was suing because he felt he was being discriminated against. The Supreme Court ruled that that the Duke Power Company was indirectly discriminating against the minorities because there was no reason why you needed a high school diploma in order to have this job, and most minorities in the area did not have a high school diploma. So for EEOC versus Premier Operations Services Incorporated, they had a policy of hiring people who only spoke English. So if you were of Mexican descent and you could not speak English, they would not hire you. So of course, EEOC filed a lawsuit on the behalf of the declined workers, saying that it was not necessary for the position that they were applying for was truck drivers. It was not necessary for the truck drivers to have to speak English in order to transport the goods. The Supreme Court ruled that this was discrimination against nationality because, again, it was not required for you to have to speak English in order to drive a truck. So for EEOC versus Abercrombie & Fitch, there was an individual who was denied being hired at Abercrombie & Fitch because she wore a headdress for religious reasons. Abercrombie & Fitch had a practice of you had to maintain a certain look in order to work in that position, and regardless if you had you wore something for religious reasons. So EEOC sued. The Supreme Court ruled that her headdress had nothing to do with the job, and that her headdress did not interfere with her performing the responsibilities and tasks of her job, even though it did not meet their look. So for EEOC versus Wyoming, a gentleman was forced into retirement from the Wyoming Game and Fish Department because he had reached the age of 45. The EEOC filed a lawsuit on his behalf against Wyoming because Wyoming had a practice of forcing people into retirement, and they didn't have a law against age discrimination. This case ruled that federal law trumps state law when it comes to discrimination. So because it's federally illegal to discriminate against age, it reaches into the states as well. So the man got his job back and was not forced to retire. For Marriott Savings Bank versus Vincent, a woman was sexually harassed at her work. She kept reporting it, nothing was done, so she quit. She then filed a lawsuit because she felt like she was being discriminated against sexually because she was a woman, and that's why nothing was done for her to be protected against sexual harassment. What this case ruled was that sexual harassment is protected under Title VII, so it doesn't matter that she's not losing anything monetary value, but since she is a woman and her sex is the reason she's being sexually harassed, that it is protected under Title VII. For On-Kill versus Sundowner Offshore Services, similar case, except for it was a male who was being sexually harassed. He reported it several times, and when he had reported it to his HR supervisor, he was called a homosexual and said that he wanted to be sexually harassed. So this reached in further into Title VII, saying even though you're a male, you can still be protected against sexual harassment under Title VII. So you don't have to be a woman to be protected under Title VII because he's still being sexually harassed, and again, that's protected under Title VII. So some of you may or may not know this, but I work for Old Navy. I've worked with the company for about 3 years, and I've been enrolled in various different managerial positions. I recently just transferred over to the Gloucester Premium Outlets, where I am a department specialist, which is kind of exciting. So one of the responsibilities of my job is that I am required to do interviewing and screening for potential candidates. So I have to know what I can and cannot ask in an interview, because there's legal ramifications if I ask something that could be perceived as discriminatory. So some of the questions that I cannot ask is I cannot ask about age. I cannot ask how old you are or when you were born. Another thing I cannot ask is about your birthplace. That's because I can't discriminate against you based on national origin. I don't want to know where you were born. I can't ask if you're a citizen because that's none of my business. Again, national origin issues. I cannot ask if you've ever been arrested. So some questions I can ask is if I were to hire you, can you provide proof of age? That's not me asking about your age, just making sure that you're old enough to work here. I can ask if you're hired, can you provide documentation that you're able to work in the United States? So in conclusion, Title VII, it gets kind of messy when it comes to protected classes and what you can and cannot do, but make sure that when you're training your staff that they know what Title VII is, what laws, who's protected. That way your business doesn't get into legal issues.
Oh, that's me.
Yeah,
Sorry. Alright, so, did I just say my name? Well, I guess not. Well, I'm Allie, and I'm going to talk about the ADA, and that is Americans with Disabilities Act of 1990. And it basically prohibits employers, local and state governments from not hiring somebody because they're disabled. And it also is in the application process. You can't discriminate against that in hiring and firing. And I guess I have more time than I thought. And the ADA protects against employees who work at a company of 15 or more, and also applies to employment agencies and labor organizations. And there are also questions you can't ask, like you can't ask someone if they have a disability, and you also can't reference anything that's a clear disability, like you never really know if they actually are or not. And a disability is a physical or mental impairment that substantially limits one or more major life activities. And even people who look or you think they're disabled, they're protected under the ADA as well. And so major life activities are seeing, hearing, speaking, walking, breathing,